Hello, everybody. Welcome and thank you for joining us today. I hope that everybody can hear us. Yep, fantastic. So I'm Tanya Tiraoro, co-director of Special Needs Jungle. I'm joined by my co-director.
Hi, I'm Renata Blair. I'm also co-director of Special Needs Jungle. This evening, we've got 90 minutes of legal commentary on the implications of the SEND Green Paper and the issues that surround it.
And so this is a donation event with proceeds being equally split between Special Needs Jungle, between IPSI and SOS SEN, as our amazing legal charities. So if you can possibly support us with a small donation, you should find the link in your registration emails and at the end of the webinar. We've also got a few snap polls to run at intervals just to gauge how you're feeling about the SEND review, and also a survey that you can participate in at the end of the webinar.
A quick housekeeping note. We hope to have time for your questions, but please use the Q&A box, not the chat. Questions in the chat won't be included as they will get lost, but you can use the chat to chat amongst yourself. You can also ask for help from our team if you have difficulties using the chat. Please also can you keep your cameras off and your microphones muted. So without further ado, we'd like to invite our esteemed expert legal minds this evening to briefly introduce themselves as we call their names. Firstly, SNJ's longtime legal correspondent, SEND solicitor, Hayley Mason.
Good evening, everybody. Nice to join you. As Renata's just said, I am the legal columnist at SNJ. I'm also director and senior solicitor at SEN Legal. Pleasure to be with you all this evening and look forward to chatting with some esteemed colleagues as well.
Next up, public law barrister, people's hero, Steve Broach.
So embarrassing, Tanya. Evening, everyone. Lovely to be here with you all. As Tanya says, I'm a barrister. I'm at 39 Essex Chambers, and this is one of the main things that I do is pontificate about special educational needs and disability law. So I'm very pleased to be doing that again this evening.
And next up, we have SEND solicitor Roxana Kosa.
Hello, everybody. My name's Roxana and I am a solicitor with Education Lawyers, which is part of Langley Wellington Solicitors, and SEN law is all that I do as well.
Fabulous. So next we have IPSI's CEO, Ali Fiddy.
Hi, thanks very much. Lovely to be here, really delighted to be here. Yes, I'm looking forward to some interesting debate.
And another highly experienced solicitor, CEO of legal charity SOS SEN, Eleanor Wright.
Good evening, everyone. Likewise, very grateful to have been invited. I've been dealing with SEN for longer than I care to admit, previously in private and legal aid practice. I think it's an excellent opportunity to discuss everything to do with this. So looking forward to this evening.
Thank you all. And we do have some pre-prepared questions that parents have already sent in. And as I say, we will be asking at the end and maybe also during it some questions from parents if you put them in the Q&A. As Renata said, only the Q&A, please. So first of all, Renata, are you going to start with question number one? Oh, we'll start with poll number one. Let's start with poll number one. Let's do that. So I will bring that up, and it's about the legal implications. Can you see that? You've got 30 seconds to tell us.
Do you understand the legal implications of the Green Paper? Answer yes, no, or not sure. So that, do you understand the legal implications of the Green Paper?
Panelists have been disempowered. We're not allowed to vote, so we're not going to.
Sorry. Well, we hope that you do. That's why you're here.
Yes, I know. But they must say no. We get immediately ejected.
Okay, so I should think that as 30 seconds just about is gone. Well, the answers would be, let's see, 53% I'm not sure, 29% no, and 19% yes. So it's just as well you've all come this evening. That's all I can say. So we'll share those results with you.
Okay, so to kick off, we're going to have Hayley up first. And Hayley, we'd like to give you 1 minute to offer your headline response to the Green Paper, please.
Oh gosh, timer. Time is never good for me, Renata, but I'll try. I think for something that we waited so long for and been quite optimistic about, so the Send Green Paper has come about from the Send Review commissioned back in November 2019 to look at why the Children and Families Act and the 2014 legislation hasn't worked as we intended it to be. The system's overrun, there's not enough funding. What's actually come about, the proposals, and don't want to put a dampener on it, but the only positive thing right now that I can see in the Send Green Paper is the one thing that we lost when 2014 legislation come in, and that was having one standardised EHC plan or statements as they then were. I don't think it's very good for parents. I think it's going to make things a lot more time consuming and a lot more difficult for parents to get their children's rights and to get provision for those needs that they're already fighting hard enough for. And I think it's just going to add additional measures in to make it even harder. So I'm not very optimistic.
That was 1 minute and 1 second, Hayley. Fantastic.
Aim to deliver, Tanya.
Steve, your headline response.
Thanks, Tanya. I'm not sure that's lawyer's code for I don't accept the premise in paragraph 29 of the Green Paper, the vicious cycle of late intervention, low confidence across the system and inefficient resource allocation. I think it's striking that the government is saying so clearly how badly things are going at the moment, but I'm not convinced that in every case that cycle does flow. I think there is a concerning, perhaps, lack of recognition that there are some children and young people who just have very significant levels of need that have to be met. So that's a real issue for me. Very concerned about the potential limitation of parental choice of school, although the wording of the Green Paper is ambiguous. Very concerned about mandatory mediation in principle and in practice. There's also 2 points I definitely would like to come back to in terms of annual review timescales and the way in which the tribunal can deal with disability discrimination claims against schools, which are 2 points of detail. But overall, I'm looking at the detail because I don't see this as being a very significant package of reforms in the way the 2014 Act was, for example.
Thank you, Steve. And Ali, your response?
Well, if any of you saw the evidence session that I contributed to at before the Select Committee a couple of weeks ago, I think you probably know what my response is, but it's not very welcoming for what's in the Green Paper. We were one of the few organisations, I think, that was really hoping it would continue to be delayed because we knew that it wasn't going to be good. We were fairly certain about that. I mean, I think I would agree with what Hayley said about the EHC plan template. I think that's to be welcomed, although there is a sense that that ship has very firmly sailed already. I think the other thing that I do welcome is the fact that the extended powers of the tribunal are going to remain, which I think was a concern given that the decision was made last summer that they would continue rather than be made permanent. I think we were quite concerned that that was going to be up for grabs as part of the Send review. Very, very concerned about the issues around parental placement and choice around placement, very concerned about mandatory mediation, concerned that that's part of a broader government agenda to kind of reduce people's ability to challenge public body decision making, which of course is particularly problematic for children and people with SEND. So yes, I mean, broadly speaking, we're very concerned about it and very concerned about the national standards and the suggestion that these are going to create a national framework, which of course already exists. And our concern is that the reality is this is going to be a method for reducing rights and entitlements.
Thank you, Ali. Eleanor, a minute for you.
Yes, and I mean, in many ways, it's all of the above. It's good, bad, and one of my particular concerns is there's so much that's uncertain. There's all this emphasis on national standards, which everybody then says, well, what are they? Who's going to set them? What's the consultation process going to be? How can you possibly make them fit around every single type of and degree of special educational needs? Slightly to my surprise, when I sat down to try to think about positives, I came up with more than I expected. but they tend to be small wins and areas where it's aspirational, but we need to see whether it's going to be delivered. And the big concern really is what's missing in terms of an adequate system of accountability. That was the thing which I think was the overwhelming theme of the responses. We want accountability, and there isn't really anything satisfactory in here dealing with that.
And Roxana, 1 minute for your headline response, please.
I agree with everything everybody said, and I'm going to start by saying, actually, well, what's wrong with the current legal framework? If it's applied, implemented, it should work, and it does work, but only when parents take an appeal to the tribunal. So I think that I'm very worried about the standards. The list of schools, because there are some areas whereby, you know, there aren't schools that can meet every need, if you see what I mean. So that's a worrying thing. And mandatory mediation, it's very rare that I've heard that it actually gets the parent the decision that they're looking for. So if they have to go through that process, it just increases the time that the child has to wait for the support that they need. So really, it's not a win for the child.
Thank you, Eleanor. And just in case you're wondering who the other people here on the chat, we have Matt, Nadia, and Nicole. Everybody will know who Matt here is. These 3 lovely people have given up their evening to help with the questions and the chat. So thank you, the 3 of you. That's just in case you were wondering who the other people were. So moving on to the questions we received now. So firstly, it says page 33 and 34, the Green Paper states, these changes will not impact children or young people already in specialist settings, but will apply to future decisions. Does this include, do you think, decisions at annual reviews when things are changing? And of course, obviously, we have this consultation. Who would like to jump in first for that? Steve, because you just doing something.
Sure, Tony. Yeah, I'm just looking at that wording, and I think it's important to cite this in the context. And it's again part of my theme that this is actually lots of little sets of proposals as opposed to one overarching set of reform in the way that the 2014 Act was. So that statement is made within the context of the specific amendments that's proposed to the process of naming the placement within an EHC plan. And so what's said in is that will only happen where there are future decisions about school places. So these changes will not impact children or young people already in a specialist setting and will apply to future decisions about school places, which does tend to suggest to me that they could apply at the annual review stage. But as Anna and others have been saying, we don't know. There's so much about the Green Paper that we just don't know, because it's, to an extent, that's fair enough. It's a Green Paper, it's for consultation. But it's very important that people point out all the devilish bits of detail that are missing. However, on this point, I just fundamentally think this is a terrible idea. The idea that someone, and one assumes the local authority, is going to define a list of schools that parents can choose from on the basis that somehow there'll be an agreement that that list is appropriate is fanciful in my experience. What's wrong with parents being able to choose any school, putting it forward, and the local authority then deciding and applying statutory provisions? It's just not a problem. This is a purported solution to a non-existent problem that is actually only going to have the effect of reducing parental choice. And will parents be able to appeal to the tribunal on a free basis for whatever school they want once the list has been handed to them? Firstly, they need to know about the ability to do that, but then is that power going to be somehow fettered as well? So I just cannot see any conceivable advantage from the family perspective to this proposal.
Who'd like to jump in next?
I was just going to say there as well, Steve's touched on it, we don't know who's creating this list. So local authorities already have the power, because obviously they are the decision maker when the EHC plan is finalised, to name the school that they consider can meet the child's needs. And we all know, as legal professionals working in this area, that those schools that are named on Section I of EHC plans are often completely inappropriate. So if local authorities are already, without this proposal in place, naming schools in Section I of an EHC plan that are completely inappropriate, and is proven time and time again at SEND tribunals that they are completely inappropriate, then what is going to make them be any more appropriate by giving them a list that presumably they are going to set for themselves, which inevitably is likely to be the cheapest option for them. And it's very much my concern that this is trying to fit square pegs in round holes. Every child is individual, and even if you have 10 children with autism, it doesn't mean they all need to go to the same school. They have individual needs, they're individual people. And I just think we're going to end up in this situation, and very much the overarching reading of the Green Paper is trying to curtail all of these individual children with all of these differing needs and different severities of needs into one type of school, because it costs less money, and making it even more difficult once they've done that to then let parents go through the SEND tribunal to actually challenge that decision. So we don't know who's going to set this list, but presumably the local authority, which has too many problems, probably for an hour and a half.
Is there anyone else who'd like to have something extra to say about this?
I think I'd just like to say that I think the idea that there's going to be a list of schools for each parent or carer to look at and pick from, I think is also a misconception. I think the reality is it's going to be an incredibly short list and could be a list of one. And, you know, that's what concerns us hugely. And I think there is part of, I mean, going back to what Steve was saying about the fact, you know, yes, it's a Green Paper, therefore, you know, it's a consultation, therefore the proposals are vague, but they are very dangerously vague in so many ways, because our sense is that actually what this is going to do is effectively remove parental choice, but without overtly saying that. There's definitely an emphasis on wanting to reduce the amount of money that's being spent. And of course, we know that the particular concern is around the amount of money that is being spent on independent specialist settings. So, you know, I think the theme that runs through this is most children should be in their local school, their local mainstream school, in their local community. Children with the most complex needs should be in a specialist setting, but not really an independent specialist setting. We really want them in maintained schools because, of course, they're cheaper. And then we're going to bounce some children, probably those who exhibit challenging behaviour, between mainstream schools and alternative provision. And I think that's the thing that concerns us so significantly.
Okay, let's move on to our next question. Now, I think almost all of you mentioned mandatory mediation. No one outside of government seems to think they're a good idea. Why do you think it's been brought back after being kicked out at the last reforms?
I honestly think it's just a delaying tactic, because if you're going to go to mediation, it's just kicking the can down the road. Obviously we're solicitors, certainly I am, you know, Steve's a barrister, and the rest of the panelists are solicitors. So I appreciate that we tend to see the cases that aren't successful. IPSI probably see some more success cases than we do, because obviously we're dealing with central tribunals a lot of the time. But I've never heard of one good success story for mediation, and I wish that wasn't the case. Mediation, the real crux of the problem is local authorities don't send people with decision-making powers to mediation. So unless we're going to actually change that, and they're going to actually have helpful mediation system where there's someone from the local authority that can make decisions and can, you know, put provision in place, can discuss an alternative outcome, they're never going to be successful, because you essentially sit around a table, discuss the problem that parents at this stage have probably been discussing for months, if not years already, and then we haven't got any way of actually, even if they say what the parents want to hear, enforcing that because lots of parents go away from mediation thinking, great, they've heard me, they really understand, and thinking things will change. And then we end up 2 months down the line and actually they haven't followed through with the mediation agreement and they're back to square one, but they're 2 months down the line. So I think that's the real concern, certainly that I have, that mediation is just another one of these things to delay things, because obviously while it's being delayed, if the child is out of provision, if they're not getting the right amount of provision, it's just money that's being saved, and we're further down the line is my concern.
Is there anyone else that wants to jump in on this one?
Well, I have had some successful mediations, but not many. And we've had an awful lot of parents reporting that it was partly or completely a waste of time. What's interesting actually is this issue about sending someone with power to make decisions, because the Green Paper says that will be compulsory, but then it is now compulsory for local authorities to attend mediation if the parent wants it. And we keep coming across instances where they simply don't. They could totally ignore the mediator. And so that then raises the question, well, how do you enforce it? Because if the parent's going to make a fuss about getting somebody with power to make decisions there, is that simply going to build in more delay whilst they try to find another appointment? And it will require local authorities to appoint more senior officers, because somebody is going to spend a lot of time in those mediations. And you know, that will need more funding, which I don't think anyone is promising to give them. But I think the main issue is really thinking, is this going to be constructive? The parties, particularly with a final EHCP, have had 20 weeks to talk to each other, at least, frequently more than that. And if they haven't managed to sort things out in that time, you know, I think they should be entitled to say, you know what, I can't wait for this child to get the right provision any longer, and we need to be able to get on with it.
And also we've been hearing that they've been sending, LAs have been sending lawyers to mediation, their lawyers to mediation as well, up against parents who are not represented. Roxana.
I was going to say, I mean, when parents go into mediation, they're not aware that this is an evidence-based approach, whereby, and they don't at that time have any fresh evidence that will persuade a local authority to make a different decision. For instance, on a refusal to assess, it will all still be based on the information that has already been gathered. And the other important thing to remember is often the legal test is not applied in those situations. So unless they are reminded of that, it's just going to carry on. So the most sensible thing then is to just appeal, because we all know that the current threshold is very low, and it's very likely that once you appeal, the local authority will give in. And without new evidence, nothing's going to change. It'll be just like Hayley said, it's kicking the can down further down the road. So and the child continues either to be out of school or not getting the support they need.
Can I chip in, guys? I just want to start. I agree with everything that everyone said, which is a bit boring, but I wanted to step back a little bit and think about whether mediation is really the right approach in this area at all. You know, I do some commercial work, not very much, and in that context, you can see why people who are litigating about money might well want to mediate, because it costs a lot of money to litigate, and it might be sensible commercially to do a deal and split the difference or whatever it might be. Should we be mediating about the needs of children who are disabled with special educational needs? Should we be doing deals? You know, what if my child has a speech and language communication need, and I've got an expert report that says that they require an hour a week of intervention? Why should I accept 45 minutes at mediation? I should be able to go to an independent panel, let's call it a tribunal, and get a decision as to whose evidence is better. It's, you know, I'm not saying mediation is never appropriate, but I do struggle conceptually with the idea that we should be trying to split the difference, trying to find a middle ground. No, we should be trying to identify needs and identify appropriate provision to meet those needs in the most cost-effective way, i.e. what the law requires. And the perfect body to make the decision about that is the tribunal.
Can I just pick up on that point really, because I would to a certain extent sort of echo some of what Steve has said. I do think that there is particularly a place for mediation in the current system when you're looking at things like refusal to assess, because I think that's quite often the first time that the local authority is properly engaged with the particular needs of that individual child. Because, you know, we know that lots of local authorities hope that most parents just walk away when they're told no. They assume that that's correct because the local authority will make the right decision and it will, you know, and they will apply the law correctly. And of course, unfortunately, we know that that is frequently not the case. And I think what worries me in the context of what Steve was saying is that this greater emphasis on mediation and the idea of it being mandatory, I think is where it does become possible that we are in a situation where people are mediating rights. And, you know, and I would bring the other example to the table, Steve, of private family law proceedings, where actually mediation can be incredibly effective, where you're looking at things like contact between the non-resident parent, where two parents are, you know, very, very entrenched in their positions. Actually, that can be a really valuable method for resolving the matter. But I think this is very much about, you know, the focus throughout the Green Paper, and I think the motivation of the government is about reducing provision. It's about giving less to individual children. And I think, you know, you have to look at it realistically, this proposal around mandatory mediation in that context. And, you know, the other thing that worries me about the mandatory mediation is also the suggestion that if you're not able to reach agreement at mediation, it will then bounce back to be looked at by an independent panel. How independent? Who will also be the same panel that will have been made recommendations about whether a child needs to be assessed, whether a child needs an EHC plan. And I think what I would just caution against is to all of the people who are here, is assuming that the legal framework and the current legal tests for assessment and an EHC plan are going to remain, because I do not believe that is the intention. I think, I feel very, very strongly, and you know, we've done a huge amount of analysis within our legal team at IPSI, but actually it seems very, very clear to us that the intention of the national standard is to replace the current legal framework for identifying, assessing, and putting in place provision for children and people with SEND, which means everything that currently exists under the Children and Families Act and the regulations is basically up for grabs. And you know, the only way they are going to reduce the amount of money they're spending, the number of children with EHC plans, the volume of appeals going to tribunal, is to reduce entitlement. And that's entitlement to assessment, that's entitlement to a plan, and that's entitlement to provision. And I mean that in the context of special educational provision within Section F and also placement within Section I.
Thank you, Ali. The Green Paper is one of its other biggest big ideas is national standards. Now, I would have been questioning this because it isn't the law a national standard already, but we don't know whether these will be underpinned by legislation. How do you think that they would be able to enforce these? Who hasn't? Eleanor?
Well, that's the big question. I very much agree with what Ali was saying, concerns about what this very vague term is designed to achieve. And I think we may well find, when we start seeing some detail, that it does water down how you can access provision. I mean, in terms of how it works, well, who knows? When they talk about national standards for the assessment process, I thought, well, that has the potential to be quite helpful, because one of the biggest problems we have at the moment is that assessment is done very badly, and Regulation 6 is largely ignored in terms of the information that local authorities have to gather. And I thought, great, let's have that as a national standard and let's actually tighten that up. But we don't know whether that's what they're going to do. And like Ali, I have my suspicions that actually it will be left just as vague as it is now, because as soon as they tighten it up, it means a lot more money has to be spent on assessments, and that will result in in an ideal world, in a better plan and a properly enforceable plan, which likewise is liable to be more expensive. So I would love to see some national standards that work in that respect. But we wait to see the detail. When it comes to national standards around provision, both at SEN support level and at EHCP level, it's that big question mark. How can you produce a national standard that will cover sort of every child from the one with very mild SEN through to extremely severe? I would have thought this is a near impossible task, and I want to know how are we going to do that? What's the consultation period going to be? How are you going to factor in Equality Act considerations? And then, yes, how is it going to be enforced?
Just a note I've seen in the chat from Christine from the Council for Disabled Children that it is a consultation. She's quite right. So it's really important for everybody to put your views forward, and we hope we've tried to make that a bit easier for you. But on this question, who else would like to say something?
I think we're in agreement, aren't we? National standard work, what is it? At the moment, it's very specific, and I agree completely with Ali. I think the overarching emphasis on this green paper is to try and make it more difficult. They are saying all of the things parents want to say, but in all honesty, the 2014 legislation gives us what we need. It's very much in parents' and schools' favour, because it says every need that a child has must be identified, and provision specified and quantified needs to be in EHC plans. They cannot deliver what's already there, and that's what they've identified. So rather than focusing on the unlawfulness of the decisions and the actual fact that the law is very clear about what needs to go into EHC plans and how children should be supported, because if they've got a need, it needs to be identified and it needs to be provided for with provision, and a suitable school needs to be named in Section I that can deliver that provision to meet those needs, which is all very clear to everybody involved. What's happening is local authorities aren't complying with that, and we know that. So what they're trying to do is actually take a step back and say, okay, we've got a real problem here. What we'll do is actually just make it more difficult to get these plans in the first place, because they're taking up so much money. And I don't want to, seem like a really negative, but it's a very big concern, and parents and schools are going to be hugely affected by this. Parents and schools, because schools are going to find themselves having such an array of children put into them as well. How are they ever supposed to support the children that they're actually being placed into their classrooms? Because they're going to have such a diverse range if we read what the green paper is saying. And I've also heard some of the parents and read some of the comments saying, this really is the opportunity for parents to speak up, because the rights are so great for parents at the moment, and you do not want them diluted because they're skirting around the actual issue. The actual issue isn't with the legislation. The legislation is great. It's just that no one follows it. That's the problem.
And also, when it's actually followed, it does increase costs. And that is, that is the outcome of going to an appeal, is that you get the provision your child actually needs to address their difficulties. And more and more parents are aware of their rights, and they are fighting, hence the increase in appeals. It all focuses around the issue of funding, but doesn't focus around actually putting in place the provision that the child needs. I don't think there's anything wrong with the legal framework. I don't think it should be changed.
I mean, and let's not forget, it's still a very small percentage of parents who actually do go to appeal.
Exactly.
Well, I mean, the obvious point which we're always making is if they genuinely wanted to reduce appeals, there would be more done about accountability, because the very easy way to reduce appeals is to comply with the law.
Yeah, and I think, I think what I would say, and this is an incredibly negative comment I'm about to make, but I think it's really important to recognise that the motivation from government on this is not about ensuring that individual children have their needs met, improving provision, improving experience. That is not the motivation. The motivation is about reducing the cost. But it's very difficult to come out and say that. We want to spend less money. We can't afford to spend the amount of money that is required in order to deliver the current legal framework. But that is the reality. And I think, you know, the reality is with the national standards, they do not fit within the current legal framework. There is no place for national standards in the Children and Families Act or indeed in the regulations. What we've got is primary legislation. We've got the regulations, which add some more detail. And then we've got the SEND Code of Practice, which adds flesh to the bones of that legislation. And in some places is you know, less than helpful. And we'd certainly like to see some improvement on that. But you know, that's the framework. What the national standards are going to do is to provide a national framework for identifying, assessing and meeting the needs of children and people with SEND. That is a replacement of what we've currently got. The only way national standards can be implemented is if the law is changed. And I think that's the real message that I want to kind of convey this evening to all of those people that are watching the webinar, participating in it. We at IPSI will be coming out, you know, the national standards are a red line for us. We will be categorically opposed to national standards because the law needs to remain as it is. We will continue to also push for better accountability because that is the only way that the current framework is deliverable. But I think we also have to be realistic about the extent to which there is any appetite for that within government. And that's, you know, of huge concern. But I would, you know, one of the national standards that's proposed is around improving SEN support and putting that on a statutory footing. We are in favour of pushing SEN support on a statutory footing, but don't do it by way of a national standard. That needs to just be done by making an amendment to the current framework that exists. Doesn't need a national standard. And I think there's a real appeal to the idea of national standards. And I think they've been presented in a way that they could potentially be, you know, very appealing to people. Oh, and you know, that there'll be consistency across the country. There should be consistency across the country. The law is the same wherever you live. The problem is not that there is the ability to exercise discretion locally. The problem is that that is what happens, and that's because the accountability framework is not sufficiently robust.
Could I just chip in on that, guys? Again, sort of trying to reflect the bigger picture, perhaps. Agreeing with Ali, this is really quite tedious, isn't it? So I need to disagree with someone at some point in the near future. But it's the SEND legal framework is special. And as someone who practices across quite a wide range of social welfare law, it's almost unique in modern social welfare law that you have such hard-edged entitlements, with no discretions, and an independent tribunal that doesn't just review on public law grounds the reasonableness or otherwise of public body's decisions, but actually stands in the shoes of the primary decision maker and decides for itself on the evidence. It's it is not something that would be created today, and therefore it is precious and needs to be defended, I would say. So I completely agree with Ali that there has to be some red lines, and that's why I think ultimately we'll never have a proper single route of redress across education, health and social care, because the social care entitlements won't be leveled up to the level of the education entitlements. And hopefully those of us involved will resist the leveling down of the education entitlements, because that would be the only practical way that I think we'll ever get a single system, is if we have a worse set of entitlements for education, and that must be resisted. So we'll probably have to continue with the current fudge, you know, where the tribunal makes these non-binding recommendations and so on health and social care, as our best case realistic scenario. The best case realistic scenario is that, as following the green paper, nothing gets worse and a few relatively minor points get better, like having a national template for EHC plans, which are going to do anyway. And as Alex says, inserting a new section 33A into the Children and Families Act that puts SEND support on a mandatory footing, statutory footing for mainstream schools. These are all very straightforward things that could be done, you know, quickly. We don't need to try and create national standards or anything highfalutin to make the relatively small number of sensible changes that the Green Paper proposes. But anything big in the Green Paper is detrimental to children's rights, as far as I can see.
Yeah.
Okay, I'm going to push you all now to see if I can get you to say anything positive at all. And so I'm going to ask you whether or not you think these proposals manage to increase accountability in any way, in your view.
No.
No.
Quite frankly,
It leaves it with the DFE essentially, which doesn't really change where we are now. They have had all that time since 2014 to make local authorities behave, and we've seen that they are incredibly reluctant to get involved when such a large proportion of local authorities are essentially failing Ofsted. It took an awful lot for them to take over Birmingham. It had descended into chaos. And there are other local authorities, I'm sure we could all name, that could do with some intervention, and it's not happening.
They're actively making accountability worse.
Yeah.
The main accountability mechanism in our system is the tribunal and judicial review, which the government doesn't like to talk about, but is incredibly important for anything that you can't appeal to the tribunal. And the Green Paper transparently is about putting roadblocks in the way of people accessing the tribunal, mandatory mediation, and then as has been mentioned, this possible third stage, bizarre stage, where you go back to some quasi non-independent appeal panel, which may or may not be given kind of IAP style powers.
Which would have made the initial recommendations.
Which is just obviously not compatible with Article 6 and the common law, I would suggest. Oh, another thing that might not be compatible with Article 6 and the common law, by the way, is mandatory mediation. There's a really interesting paper out there about whether or not mandatory mediation is human rights compliant and common law compliant, and the jury's out on that. So it may not even be lawful, but whether or not it's lawful is a terrible idea.
And also whether there's any interest in whether or not it's lawful, I think is also important, given that, you know, the other thing that of course is on the agenda is the repeal of the Human Rights Act. I mean, there is no appetite for this level of accountability, I think. And yeah, I mean, in terms of whether there's anything in here that's positive, I think there's very little. I mean, it's a huge concern, and yeah, we're very, very worried about it. At IPSI, and the accountability framework is, I mean, I think the whole chapter on accountability just fails to address the issues. The one thing that has been consistently said by I think most people is that the accountability framework needs to be strengthened, and yet that chapter on accountability in the Green Paper just fails to address accountability and seems to be interpreted, I think, intentionally by the DFE as being about being clear who has what responsibility. That is not about accountability. And actually, it's very clear who has what responsibility already. Thank you very much.
Yeah.
I looked at my little list I mentioned of what might be positive, and there are all sorts of question marks. I mean, there's things, and there's small wins. I mean, there's the uniform EHCP, which we've talked about. There's things like improving the funding mechanisms for PRUs. That is a plus. Perhaps some more investment in special schools, but that goes against all the emphasis on academization, which I'm not particularly keen on. Better early years provision, but let's see if it happens. Better teaching, better teacher training, but I would like to see exactly how that is going to work in terms of SEN, including, are they going to be trained on what the law says? Sort of more power for local authorities to direct multi-academy trust to admit, and rather more uniform requirements of academies rather than the current sort of network of funding agreements. But it is, I do wonder how on earth the poor local authority is meant to have all this extra responsibility when all the control is being put into the hands of multi-academy trusts. And that again is not spelt out. So there's sort of little positives, but there's sort of big question marks around them.
I think, Renata, in relation to the question of accountability, like Steve said, it says enough that we're all practicing in this area, you know, across obviously charities, parent groups, etc. And we're needed, you know, because that is sometimes parents' only option, because the local authorities are not making decisions that are lawful, because the law is there and there's nothing wrong with the law if it's properly followed. And actually decisions are being made that are not compliant with the law, and parents are challenging them through going through the SEND tribunal. We know that through the fantastic work that Matt does on Special Needs Jungle with all of the statistics. The amount of statistics coming out of how many parents win in tribunal against local authorities tells you everything that you need to know about unlawful decisions, because it's not that everyone's presenting their case absolutely fantastically. It's that when they're going to the tribunal and the tribunal is saying, this is the legislation, this is the legal test, and what you're telling me is a policy, it is not the legal test, and unfortunately we are going to apply the legal test. Most local authorities concede way before a hearing. They don't even have to get to a hearing, because they're faced with solicitors, someone challenging them on the other side to say, this isn't the legal test, stop being stupid, apply the legal test, and they concede the case. And in actual fact, like Steve said, the accountability is going through the SEND tribunal. So what have they tried to do? Put enforced mediation in place, and then put another roadblock by going back to the original panel that's already decided the unlawful thing in the first place, to just make it a bit longer for parents, a bit more stressful for parents who, let's not forget, is actually at home looking after the severely disabled children that the local authority aren't stumping up any money for in the first place. So although parents already have far too much to do and far too much on their hands, we're now expecting another layer and another layer. And accountability is the one thing that this green paper should have addressed and hasn't. And what it's instead done is just put some of these little things in place for us to discuss and kind of skirt around the wider issue while they try to sneak in through the middle and change the very clear legislation that we have. It's not the law that's a problem, as I said earlier, it's the enforcement. And every single time I go to these SEND user group meetings, and we will all know there are specific local authorities up and down the country who we are against all of the time, who are coming up against all the time. And the amount of times we've asked the tribunal, is there anything that can be done about these local authorities that are just not following the law? And that is what we've been asking for. We've been asking for that for years and years and years. And instead, these proposals that we've got out of the green paper is not going to change that unless there is some form of accountability. And that's what's gravely missing. As I said, if anyone missed it coming in, my only positive, there are a few, but the main positive for me is what an EHC plan is going to look like, as in it will look the same across all local authority areas, which is great, but we did have that with statements, and somebody in government thought it was a brilliant idea to let local authorities distinguish themselves by having their own forms, and then have rapidly realised actually that was a terrible idea, and let's revert back to how statements were in the first place. So when the only thing that they changed is actually the one thing that's now positive, I think that says quite a lot.
Just to point out, as Matt's dropped into the chat there, 4% of LA decisions were upheld at the first tier tribunal, only 4%, which is 8 times worse than the DWP for PIP and 10 times worse than the Home Office for immigration, for immigration, of all things, so that says something.
I think that's really important, Tanya, and the reason why we're also negative is because we're all lawyers. There may well be other bits in, not because lawyers are always negative, you might be, but because there may be other bits of the green paper, policy bits that are positive. Some of the content around inclusive schools, for example, which has been raised in one of the questions. But from the perspective of lawyers who put the law into practice every day to try and protect our clients' rights, there is nothing positive in the green paper. And as Ali, I think Ali's call to arms and an alarm bell rightly sounded, because this is really serious. We might be about to lose, or what is under threat is the gold standard social welfare entitlement for disabled children and young people.
And it's not, let's not forget, it's not just the green paper for SEND, it's the green paper for SEND and alternative provision, because the DfE says last time around we forgot all about alternative provision. Why do you think that they've put so much emphasis on alternative provision and so little emphasis on SEN support and teacher training? Ali.
Because I don't think they know what to do about alternative provision. So the easiest thing was to shoehorn it into this green paper. That's my honest view. I don't think I think it just is as simple as that. I'm not sure there's any greater thinking than that. But I also think that this greater emphasis on inclusion in mainstream, which, let's be clear, certainly at IPSI, we are really fully on board with the idea of children being educated within mainstream schools where they are properly inclusive, where they're meaningfully included, where it doesn't mean that they're actually excluded because actually they're not properly included within the school environment, and their needs are not being met, and they end up either being literally excluded from the school or being very, very isolated within that environment. But it doesn't work, does it? There will be a lot of children who don't fit in within that mainstream environment from the perspective of the school. And I think that's where alternative provision becomes relevant. And that's what I said earlier about this idea of putting children whose behaviour perhaps is challenging in alternative provision, perhaps on a bouncing back between mainstream and alternative provision on a regular basis. And that's certainly what really worries us. And I think there is nothing in this green paper that sets out a meaningful agenda and framework for properly including children within mainstream schools. And the idea that there is not currently an entitlement to that is also a nonsense, because of course there's a very heavy focus on children being included in mainstream schools as it stands. The reality is that their experience in that environment is often so negative that it's just not an appropriate setting. And I think parents and carers need to be really aware that that's definitely a primary aim of the proposals set out in this green paper, is for more children to be educated in their local school, their local mainstream school, in their local community. And whilst that may be the ideal for many children, it will also not be the ideal for a whole load of other children.
What worries us about it is the context, particularly if you read this with the consultation on behaviour. There's very much emphasis on this in connection with behaviour, even though it recognises that alternative provision will go beyond that, include hospital, schools and so on. But it's very much an emphasis on behaviour, and there's always a bit of a tension between the needs of disabled children and the emphasis on fostering good behaviour. Obviously, everyone wants their child to be in a nice, quiet, disciplined classroom, but then how does that work in terms of inclusion with that child with Tourette's, or the child who isn't properly supported and has a meltdown, and you don't want them to be punished for being disabled. And there's a concern with the emphasis on AP, particularly with academy trusts, that it becomes very easy for each academy or trust to have its AP as a nice place to shunt off all those slightly awkward children who are disrupting the classes or who won't get the great results and will sort of muddy the league table positions of the mainstream schools. I mean, I hope I'm wrong, but there is just that flavour around it.
I think, and also the fact that they're not seeing behaviour as communication. So it's talking about managing behaviour rather than looking at what needs are not being met that have caused behaviour. And so you end up with this vicious circle where children are sent to AP and then their behaviour is managed and then they're put straight back into the school that probably traumatised them in the first place, because no one's actually looked at what their needs were and what needs to be changed in the school. You have this constant vicious circle that re-traumatizes the child.
And I think I absolutely agree with what you're saying, Renata, and I think added to that, the new national standards, which are really the new law, will mean that those children are probably far less likely to meet the threshold for an assessment. So it becomes even more damaging.
It will also, sorry, I was going to say, it's also unfairly target certain groups of children as well, because no one ever looks at intersectionality and how things unfairly impact certain, communities as well. And that, of course, intersectionality isn't even discussed in the Green Paper, let alone how some of these proposals are going to impact on marginalised communities.
Definitely. Just on the topic of vicious circle, do you mind if I share my screen quickly so I can show people what that diagram looks like in the Green Paper? Because I think it's really important. Oh no, I can't. Never mind. Those of you who've got the Green Paper to hand, it's a couple of places, I think, but it's on page 23. That the link, I think, between SEN and AP
you should be able to now.
Oh, brilliant! Thanks. So yeah, the link between SEN and AP, I think, is made good by this analysis. Because what is said is that there's a vicious cycle of late intervention, low confidence across the system, and inefficient resource allocation. And so the suggestion is that the escalation of need results from these things, and we need to intervene to stop that escalation of need. And so perhaps AP is a part of that intervention process. Again, not necessarily, I think, recognizing the fact that there are a significant cohort children and young people who just have very significant levels of need and will always have those very significant levels of need, and what the law requires is those needs to be met. Presumption in favour of those being met in mainstream, specialist provision, where that's what the families want and that's what the evidence indicates to be necessary. That's fine in my view. We don't need to change that. What we need is to ensure that there's a rigorous focus on that statutory process. And my problem with the Green Paper is that it feels to me like it's just coming from completely the wrong place. The analysis is just completely flawed, and it isn't informed by a proper understanding of who this cohort of children and young people are. Certainly not who all of this cohort of children and young people are.
I spoke to somebody this morning actually whose son is 5, ASD and ODD, and has been permanently excluded. And I asked, has anybody applied for an EHC plan? No, they just think he's badly behaved. And I just didn't know what to say. Sadly, the parent was focusing on the exclusion, and I was saying, well, we need to give some priority to the fact that somebody needs to understand what his needs are, and he needs the provision to address it. Otherwise, he'll go somewhere else and the same will happen, because he's not going to get well. It's not an illness. He's going to have that, that is it. He's got ASD and ODD. So, it's got to have the provision in place, but nobody had actually applied. The school didn't think he would get one. But he's now going to go to an alternative provision, which probably still won't understand his needs.
Steve, one of the things that made me laugh, cry, page 66 of the Green Paper says, local authorities are uniquely placed to be a champion for the best interests of every child and young person in their area, which the irony is astounding, because how many parents on the webinar this evening would have never seen somebody from the local authority and have been invited to every annual review, because the amount of annual reviews that parents go to where somebody from the local authority doesn't even attend the annual review and just looks at them as some paperwork that goes across their desk. And we obviously know the problems that parents face in terms of actually getting local authorities to comply with the timescales around EHC plans as well. How are they supposed to be championing the needs that they don't even attend annual reviews for? And it's not asking much, is it? It's once annually, and they still can't comply with that. So how are we expecting, and I saw a parent earlier who commented similar point with mediation, local authorities aren't going to annual reviews, yet they're suddenly going to start going to all of these mediations. So where are these people coming from? It's a bit like the schools. all of these children's needs, the square pegs in the round holes, are going to be met in schools that don't exist, let's point out. So all of these schools are just going to crop up in every local authority area, we're assuming, in order to find the right amount of schools in the right local authority areas. It's just, it's a farce of actually trying to skirt over what the real issues here and the dilution of rights and get it through while focusing on some of these menial issues that actually aren't an issue if you speak to the people actually in the area, for parents and obviously young persons with SEN.
Okay, let's take a very quick break now for our second poll, and then we'll take a couple of questions from the attendees. So our poll question is, do you think the Green Paper sets the right priorities? Your options are yes, no, and I'm not sure. And we'll give you about 30 seconds again. I think there's an overwhelming response here. An unsurprisingly overwhelming response. Yeah, I think that we probably don't need to give that any more time. It's quite clear that we're all in agreement, except for we've got 1% who say yes, 92% who say no, and 7% who aren't sure.
Okay, so let me know, has the quiz disappeared? It has for me. Has it disappeared for everybody else? Good, excellent. So I've seen an interesting question in the chat, in the Q&As rather. What does the panel think is missing from the Steve? Hand up.
I've got one, Tanya, and it's a question or a comment that I've been watching in the chat and the Q&A. The Equality Act is missing. Fundamentally missing from the Green Paper is any analysis of the important implications of the Equality Act for schools and how much the Equality Act ought to be driving better inclusion in mainstream schools. In fact, the solution to the problem that the government has identified is the Equality Act, and ironically that's completely missing from the Green Paper analysis. I think that's really concerning, and one of the few references to the Equality Act is about remedies in the Tribunal for Disability Discrimination Claims Against Schools, but that paragraph of the Green Paper doesn't actually mention that the problem, potential problem that people need to comment on is whether or not the Tribunal should be able to award damages. And that's actually the issue that's the subject of a judicial review claim that I'm instructed on at the moment. So I won't say anything about the content of that, but that is the issue, and that isn't actually flagged up for people. So that's what that paragraph's about, if anyone was wondering, is whether the Tribunal should have the power to award damages. But save for that discussion, which appears at the end, I think, of chapter 1, there's almost nothing about the reasonable adjustments duty, the way in which schools need to avoid indirect discrimination, public sector equality duty, etc. And that really concerns me, that such a massive part of the legal landscape is just not considered in the Green Paper.
Although I
me
feel
as well.
slightly assured by that, in that it's not up for grabs as well.
It depends which end of the telescope you're looking from, Ali. Yes, that's good. We're not going to repeal the Equality Act yet. That's good.
That is a worry then, isn't it?
One of the things that I would have liked to have seen, and is something that we campaigned for when the 2014 legislation came in, and obviously other bodies did as well, is EHC plans for children at, well, young persons at universities. I think that's something that's massively missing for the cohort, because you don't get to university age and just suddenly stop having SEN. And I think there's a massive group of young people that are missed there. And we've seen it, you know, you've seen it in all of the news reports, lots of sad stories of, unsupported young people at universities, and sad, you know, there's been the case where lots of compensation was awarded against for one family who fought against one of the universities for the failure of any support while their young person was there. But I think that's something that's massively missed. because we have got very bright academic young people that go to university, lots of them, that are not supported by plans. And I think that's something that we certainly would have liked to have seen in the Green Paper and is missing, and we would have liked to have seen in the original legislation as well, following students through university.
It's something Renata and I are also really passionate about, both being parents of young people as well.
Well, I mean, I think the obvious one is accountability, which we have talked about, but yes, I recognise we're not going to get satisfactory accountability. There is just a thought around mediation. One of the things that has been working rather well recently is judicial alternative dispute resolution, which currently is just limited to appeals about Section I, and it's actually a process where a local authority has to send a senior person, decision maker, up to this process, which will be run by a judge. And for the first time, I think for many of them, it's when they learn what the law actually is and what the evidence is they need if they are going to have a hope in hell of defending their case. And it does lead to a lot of cases being settled. And I think if they want to reduce tribunals, at least tribunal hearings, that it would be an idea to extend that and to push it into a much earlier stage in the process. I mean, there is a similar process in civil litigation. And so it is something that could translate. But if you had that process at the beginning, when both parties come, as it were, in front online of a senior judge, who basically spells out to them without considering the merits that this is what the law is that you have to deal with, and this is the sorts of evidence you will have to do to produce. It will, I'm sure, help in securing much earlier settlements of these cases, and that will in turn reduce expense on tribunals and get children getting the right provision at an earlier stage. It's a win-win.
Okay, let's move on to another question from our Q&As that have been typed in tonight, which is how are parent carers supposed to understand, comment and be involved with all the consultations that are out at the moment? It seems as though they're all sent out at the same time to confuse and totally consumers. How can all of these be looked at and see how they impact on each other and ultimately our children and young people? And I'll just add to that, also there's been some talk from Ali about a call to arms, which, you know, got a lot of people going in the chat. Have you got any ideas about how people can come together and respond to the consultation in a way that will be really effective?
Responding in the first place is the start, even though it seems like something really stupid. And I think that particularly when there's lots of consultations out, there's such a thing as consultation fatigue, and you think that there's so much going on, you get tired of either responding yourself, or you think, oh, other people will say something. And that is a real fear, because if you don't say that you don't have to do it in any particular way, but if you don't say what your concerns are, there is that worry that they won't be heard. And obviously, hopefully, this is giving everybody a bit of an insight of some of the very clear rights and law that we've got that might be lost if we don't have the call to arms. Hopefully we're all doing our jobs, otherwise that's worrying, because obviously lots of us have got various things on our websites. Obviously, especially Jungle, you've got a very helpful page on your website helping parents. I know IPSI's got theirs up, and I've seen others as well. So everyone who's practicing in this group have got templates and ways that you can respond, and especially Jungle, obviously go on there, it's your main port of call. But I think I'd really stress that because there's so much coming out at the time, lots of us are jumping on and trying to read them. Parents, you know, they're not lawyers, and that's absolutely fine. You're not intended to be, and we are trying to go through and make them as approachable and friendly as possible to get the key points down for you. I've seen a post from you this evening, Tanya, saying we'll get it out on Monday because we're only human, which we completely understand. But I think the main concern for me is people thinking that they don't know what to say, so they don't say anything, or they get this consultation fatigue. And I think I really just want to tell people that you have to have your voice heard, otherwise we will stand losing some of these key rights. So anything that parents can say, this is the opportunity, and we've got until the 22nd of July to file what you want to say inside and outside of government. And the more of us that can do that, the better.
I would say that we have prepared these single answer forms on our website under the heading of send review. So if you only want to answer one question, you don't need to plow through the entire DFE response form. You can just answer that one to us, and we will 100% guarantee that we will submit that along with our response, incorporating it into what we put in, and also as an appendix, so that everybody's words go in as they've written them as well.
Yeah, and just to add to that as well, don't feel that you are restricted to answering the questions that the government is asking, because they're not the right questions, actually.
Yeah.
And if there's something that you want to say that isn't being asked, or you just want to make some general comment, do that. Use the resources, for example, that Special Needs Jungle have put together. You know, do it. Use another organisation, an organisation, to enable you to kind of say what you want to say. But if there is one consultation that you respond to amongst all of these that are out, make it this one, because this is the one that is proposing change to the law.
I would agree with that, and everybody needs to respond, really, because otherwise we will probably be taking a step back, really.
Just on that point about the questions they don't ask, there is one catch-all question at the end, something like 22, which is anything else, and that is probably the one to use for all the things that you have been itching to say and none of the other questions asked about. And sort of the list
in our response, we haven't answered any of the questions because we've just gone on an absolute ramble of all the things we're disgusted with.
I need to interrupt here. As somebody does sorry to interrupt, Hattie, but as somebody who's done an awful lot of consultation judicial review cases over the years, it is really helpful to answer the questions as well if you can. Because the problem is, if you don't answer the questions, then when the government does the analysis of the consultation responses, although they have to deal with the free text, of course, you won't appear in the stats, and it will allow potentially a misleading impression of the statistics to be given. I'm not criticizing government for that. If we don't answer the questions, they're entitled to say, you know, 93% of people who did answer the question thought it was a brilliant idea.
That's
so
okay,
I understand why.
They'll just compare the last question with the rest of the questions and have a disproportionate answer.
I mean, where there's yes and no's, it's hopefully relatively straightforward. And I'm not suggesting people need to write essays even for the non-yes or no's, but it is helpful in any consultation, I'd suggest, to answer it, as well as, you know, giving your full and frank analysis.
I think that's what parents need to be informed about, because it does read very much, if you don't know differently, that you can only respond to those questions. So respond to the questions as Steve is saying, but if you want to say something in addition to those, then do that, because you are not limited by those specific questions. Definitely. And being the critic, I think that they are set up in a way that they are getting answers that they want to hear. So obviously you need to give all of your views as much as you're able to, and use the last question as far as you possibly can to portray those views as well.
Couldn't agree more. Can I just chip in on consultations more generally, because someone's put a very helpful and slightly terrifying list of all the live relevant consultations on the chat, I think in the Q&A as well. It's typical, I think, that we get a lot of education type consultations at this time of year. I don't think there's necessarily anything sinister about that. It's just that that's you know, how the cycle works, but it is very, very onerous. Just a word, if I may, on the consultation about timescales for amending EHC plans. This, which is flagged in the Green Paper, of course, this is the direct response to the LNP and Devon judgment, which I was instructed for the claimants on. That case is finished, so I'm a little freer as to what I can say about it. It was in that case that the High Court established that there is currently a fixed time frame for producing an amended EHC plan after an annual review, and the sum total is 12 weeks at the moment. And in short, what the proposal is that there should still be a fixed time frame, which is better than what was understood by some to be the law before, but that it should be extended to 16 weeks. And the rationale for that is that more time is needed to improve the quality of the resulting plan. I think, again, that's a policy question that people will take a view on. What is really important, again, is that people who have experience of annual reviews respond to that consultation. At least on that question, there are other questions that people may or may not want to respond to, and set out why it might be so important to have a tight and fixed time frame, because of the experience that people have. Some of the tweets about this are making crystal clear, is a million miles away from the law, even on a reasonableness analysis, which is what local authorities were saying was the position before. So that one's really important, I think, for those who are currently in the EHC system and have knowledge of EHC plans. Others, some of them are very, very technical. People may or may not have things to say about them, but that is really core business for us, I would say, alongside the Green Paper consultation itself.
One of the things that we haven't mentioned, but I've had questions about here, is about the ideas for national bandings and tariffs, and what problems do you foresee with these sitting alongside the statutory duty to secure provision? Would it take priority if the required provision didn't fit with any particular bandings? And what do you think about bandings in general?
I don't like them personally, but you're again trying to fit a child into a particular band, and it may well be that, you know, the threshold between one band and the other is only slight, but they still make a decision to go with the lower one so that the needs are not all being met. I mean, I personally don't like them. Currently, you know, it is about identifying all needs and making sure the provision is available no matter what the cost, really. And that's how it should remain. You know, how flexible can they be? You know, I don't think they're needed. I mean, I know local authorities have them, but I always, you know, parents always contact you and say, well, they put me in band 1, and I said, well, I don't know what band 1 is. Exactly. And to be honest, I don't care, as long as you know your child's needs are listed and the provision is in there. You have to have the funding to deliver what's in there.
I've done several.
I actually tell the parents not to worry about the funding, because it's not their concern.
I mean, exactly on that point, Rosanna, when I've done judicial reviews about banding, and the Hackney case went all the way to a judgment, and Hackney's system was upheld by the High Court as being lawful, very much on the basis, I suggest, of what the evidence said to the court, which was that children could be put between bands, that there was no cap, that people could be above the top band. So essentially the banding system was being used, paraphrase, as a way of providing a ready reckoner as to the funding allocation to schools. And on that basis, the court was quite happy with it. So it's not, to me, a problem per se to use bands, so long as they don't cut across the statutory duty to secure the provision. The question is, as Ali says, are we still going to have that statutory duty? Because if you then take the statutory duty in section 42, you know, the core element of the statutory scheme away, and we only have broad bands of provision, then we'll have a much worse system, and that needs to be resisted at all costs.
Yes, it comes back to that red line, really. If we keep the current law, we don't really care about banding, but you know, if it changes, if there's any watering down of the requirement to specify and any watering down of enforceability, then it starts mattering a lot, because children will not fit neatly into those tariffs and bans.
Okay, let's move on to another question, which actually touches on the schools bill. You'll be delighted to hear, which also obviously everyone has quite a lot of thoughts about. So the question is, even if the Green Paper proposals don't make it through, will the newly proposed schools bill have practically the same effect in any event? Aren't we damned anyway?
No, because we've still got sections 42 and 43 of the Children and Families Act, and we'll have to, you know, dig the trenches to defend them, because no matter what the Schools Act ultimately says, there is at the moment still a duty to secure all the provision in an EHC plan, and for schools to admit children where they're named in section 9. So unless and until those go or are undermined, how schools are organised is really neither here nor there for children with the EHC plans. Of course, children at SEN support, there's a much greater degree of concern, but the Children and Families Act scheme sits on top of all the architecture, the statutory architecture in relation to schools.
Anyone else on that? And we seem to have lost Ali for a moment. Hopefully she'll come back up. A question here about, we've talked about AP. What does the panel think about the role of AP that has been envisioned in general?
I'm slightly stuck about what the question means.
What are the views? What are your views about the role envisaged for AP? Maybe I didn't read that. Go ahead.
Well, I essentially, it's roughly as I think we said before. I'm not too sure why there is this emphasis on AP, but we have this worry that there is the emphasis on AP for behavioural issues, and that it becomes a convenient way of shunting inconvenient kids to the side, where their needs are perhaps not necessarily being met properly, and that they are, although there are pluses in terms of the emphasis on it being time limited and so on, there is this concern that it will result in kids actually just bouncing back and forward, because it always has been a bit of a problem with some schools, particularly some academies with a lot of emphasis on discipline, that children with SEND are not welcome. This is quite a good way to deal with that problem, and it may become easier.
If no one else has any other comments on that, I'll move on to another question. There is much in the Green Paper about more inclusive schools and settings. Can you see anything in the paper that might enable schools to be more inclusive? And what is the one thing that the panelists would want to see added through the consultation that might enable schools to become more inclusive?
I don't actually think the problem is with schools becoming more inclusive. I think the problems that we've already touched upon is the possibility that parents will be restricted in which schools they're able to ask for, in obviously from this list that we don't know who is creating and how it's going to be confined, because there is a parental obviously right to mainstream preference of school if that's what they want to do. But I very much echo this sentiment that I reached earlier, where you're trying to fit children with very, very different needs into one type of school and expecting everything to work absolutely fine, in systems where teachers are not taught the right amount of disability and SEND training. It's very quickly glossed over in the training that they have at the moment. There's no mandatory requirements for teachers to do special needs training, and that's putting an awful lot on SENCOs. Obviously there is SENCO and some changes proposed to SENCOs in the Green Paper, but what it essentially boils down to is, oh, we'll introduce a new qualification for SENCOs and we'll give them some administrative time, because they moan that they don't have enough administrative time. The reason why they don't have administrative time is because they're continually required to do things by local authorities that aren't actually required, that takes up all of their time. So they would actually have a lot more time, SENCOs, if they weren't being required to provide, 5-7 terms worth of evidence before they're getting increases in provision that they're often fighting for. And I've actually just done a training session for some SENCOs today, and some of the stories they tell you are horrifying, absolutely horrifying. And talking about timescales that we've just touched upon as well, where then many parents, and I've seen it in the chat today, aren't even getting decisions for years, let alone weeks. It's absolutely barbaric. So I think just saying we're going to create inclusive schools are inclusive. Schools are doing the best they can with what they've got. The problem is that schools aren't being properly funded in order to put the support in that the children often need in order to be in that school. And parents then will seek to go to other schools that obviously can meet their needs, because this solution of just putting all children with their varying needs and cognitive abilities into one setting, I just do not understand how that is going to work.
One quick question here. I don't know if any of you will have a view on this. Someone is concerned that specialist advice will not be required after the changes. For example, will the role of the educational psychologist remain statutory, for example?
Who knows?
Yeah.
It's in regulation, so it's relatively easy to take away.
They do actually say something about putting more funding into training educational psychologists. Not very much. It's really quite stingy, but that does certainly suggest that will stay.
Mm.
And I've got 1 minute to answer this one. Sorry, don't run over. Do you think that the recommendation on a law commission review for disabled children as proposed in the care review is helpful?
Got to take that one. Yes, massively.
I was just going to say, Steve was running for this.
My mute button gone. No, it's hugely overdue, I think, but very, very welcome, because disabled children's social care, if anyone's tried to read the social care children's services chapter of our handbook, quick plug, it's not straightforward at the interface between the Children Act and the Chronically Sick and Disabled Persons Act. You can get there, but it does take quite a few wet towels to really understand how the duty impacts on the discharge of the functions under Part 3, etc. We need, I would say, a much more coherent system for disabled children's social care that properly links into a modern education and NHS system as well, and isn't rooted in legislation that started in 1970. But that then needs to link into the reforms in the care review that are suggesting potentially amalgamating early help, which is an entirely non-statutory policy agenda, with children in need, which is statutory services. So again, there's loads going on around children's social care too. But the Law Commission's function is to do cool-headed reviews of complex legal areas and come up with things that work, like the Care Act, which, broadly speaking, as legislation, lawyers look at the Care Act and go, yeah, that works, it makes sense. Implementation might be a whole other thing, but it works legally, and I think we could do with that for children, disabled children as well.
Anyone want 30 seconds to say anything else that you've got a burning desire to say this evening?
My only burning desire would just be to echo what we've already said, is that parents have a voice, and we know they shout them louder than anybody else, which we're ever so grateful for. We do have a system at the moment. We have very clear legislation in comparison to other areas, as Steve has said, healthcare, social care. This is one of the areas where we have clearly defined legal rights that are in parents' favour to ensure that children's and young people's needs are very specifically set out in EHC plans and very clearly defined, and provision is supplied to meet those needs. So even if you think you're not going to make a difference, it's just to encourage everybody who's been listening tonight to go onto the various websites, go on to Special Needs Jungle. They have made it as easy as possible just to say your part and make sure that you do respond in some way with your concerns so that you are heard, because it's very important that your response to this consultation is heard by those that are putting these proposals in place.
We don't want the legal framework to change. What we want is for it to be implemented, and that's what's not happening, really.
I think we'd all agree with that. So our final poll: will the green paper as it stands fix send? Off you go. 30 seconds.
People's needs are very specifically set out in EHC plans and very clearly defined, and provision is supplied to meet those needs. So even if you think you're not going to make a difference, it's just to encourage everybody who's been listening tonight to go on to the various websites, go on to Special Needs Jungle. They have made it as easy as possible just to say your part and make sure that you do respond in some way with your concerns so that you are heard, because it's very important that your response to this consultation is heard by those that are putting these proposals in place.
We don't want the legal framework to change. What we want is for it to be implemented. And that's what's not happening, really.
I think we'd all agree with that. So our final poll: will the green paper as it stands fix send? Off you go. 30 seconds. Got 10 seconds left. Someone has said yes. I bet I know who that is. Okay, so here we go. Let's share the results with you. 1% said yes, 98% said no, and 1% said I don't know. Fair point. What are your views, panel? 2 minutes left.
No.
No.
Absolutely not.
As Ali's rightly said, the key agenda must be to stop things getting worse.
Yeah, exactly. It would make it worse as it stands.
I just want to say thank you to all of our amazing panelists. I think everyone will agree it's been such an incredibly interesting, enlightening and thought-provoking session. We hope it's also given you some clarity about the green paper. So I just have the time now to say thank you to all of our panelists: Hayley Mason, Eleanor Wright, Ruxana Kosa, Ali Fiddy and Steve Broach. And thanks also to everyone for joining us and our team of helpers this evening: Matt Keir, Nicole Lee and Nadia Turkey.
We hope your questions were answered, even if the ones you put in the Q&A, the direct one wasn't fully answered. I think that most of the ones that I saw, we did touch on. We're putting the recording on YouTube in the next 24 to 48 hours. That's if I don't sleep. Might be a bit longer than that if I do. And don't forget, this is a donation event. So if you can afford a small donation, we are splitting the proceeds between IPSI, between SOS SEN and ourselves to help with costs. The donate link is bit.ly/SNJ roundtable. Renata?
Yeah, so just once again, thank you everyone. Thank you especially to our panelists. We'll be sharing a recording. Please do share it on your social medias once it comes out, because we think it's really, really important that people see this, especially the call to arms, because we need as many parents as possible to take up the mantle and answer the questions on the consultation. So thanks again everyone for your time.
Thank you, and good evening. I'm going to end the session now. Thanks very much.
Thank you, everybody.
And if you
Thank
see the
you.
survey, please also do fill the survey in.